exactly what they're seeking. A summons is a formal legal instrument used to notify a defendant that an action has been started against him or her. The summons is usually served on a person along with the complaint. It requires the person named therein to answer the complaint. So really that's what it is. It's summons. You know, so they serve you with the summons saying this is what the lawsuit that they're bringing against you is. A subpoena is a legal instrument served on a witness demanding that he or she appear in court to give testimony. Everybody knows what a subpoena is, right? You know, it's just a document that says, you know what, you're a material witness to this thing and we need you to come, and you don't have a choice. Once you get served, you have to go. You know, and I've had times when, you know, people don't come on subpoena. Well, guess what? The guys with the guns and badges get to come pick you up and you get a free ride to the courthouse. And then you have some other things waiting for you too.
Nice bracelets too.
Nice bracelets, maybe a fine, you know, so if you ever get subpoenaed, I wouldn't take that very lightly. An affidavit is a written statement of facts made voluntarily and sworn to under oath as to its authenticity. It can be made by any person who has any facts or knowledge concerning the litigation. An affiant is a person who makes the affidavit. You understand that? Pretty self-explanatory. A deposition is a testimony of a person made under oath and given with notice to the opposing side for the purpose of cross-examination. It is a discovery device used to get information concerning the facts of the case. A deponent is the person who is given the deposition. Pretty self-explanatory too, of what a deposition is and what you call the person who's being deposed, a deponent. Jurisdiction is the authority or power of a court to hear a particular cause of action and to render a lawful and binding judgment against one or more defendants. Jurisdictions may be concurrent, that is, two or more courts may have jurisdiction over a particular cause of action in which the case or the attorney may choose the best forum for the client's interest. A court must have jurisdiction over the subject matter of the litigation, over the person or the parties in order to hear the case. So, like say you live here, you got into an accident with a guy that's from here, and then you go file an action against him in Guadalupe County. No, it's here. You live here, he lives here, so it's going to be here, okay? Or you're getting divorced. You know what? I know the judge in Comal County. I'm going to go file it up there. No, they don't have jurisdiction to hear it. You know, it's where the person lives. So that's what jurisdiction means. That they have the right to hear that case because it's in the county that they're in, or the court that they're in. Does that make sense?
I want to file something with someone here. I live in Austin, they live here in San Antonio, and whose jurisdiction?
I guess it would depend where it happened. You know, like say you got in an accident here, you'd have to file it here. Because a person lives here, he lives here. Is that what it was?
Oh, no, I was not going to because I don't want to get into
Oh, yeah, sorry. Yeah. But you know, say two people get divorced and, you know, one lives here and the other one lives in Houston. You know, with a person bringing it, whoever I guess has, wherever you live, the person who's bringing the divorce is where I believe it's filed.
It's not wherever you got married?
I don't think it's necessarily where you got married. No, it's where you call home. And home has to be, I think you have to have lived there 6 months. 6 months. And that's home. So you can't, you know, like, well, I'm going to move to Houston because I want that guy to travel every time for these hearings. No. You just moved there. You know, you've only been there a month. It's still here. So you're still considered a resident here. Okay. The venue is a geographical location where a case is tried is called a venue. So that, you know, if you're from Bexar County or whatever, the venue is Bexar County. If you're from Seguin, then it's Guadalupe County. Or if it's New Braunfels, then it's Comal County, or whatever. So that's the venue, and that's all it means. Venue is just a fancy word for the location where the case is to be tried. Discovery is legal matters, which refers to the whole process of finding the facts relating to a particular lawsuit by various legal means afforded by the parties. A prime example of discovery is taking the testimony during a deposition and using that testimony to gather the facts about the lawsuit. The process of discovery follows strict rules and procedures. So that's all it is. They take the deposition to find out. It's a discovery process. You know, they're trying to discover what you know about the case. So that's why it's called discovery. They're trying to discover what you know about it and if you know enough about it. The court docket or calendar. When a legal proceeding is filed with the clerk of the court, the docket of the case is assigned to either a numerical order or divided into various subject matters. Some courts use a method to keep track of the number of lawsuits filed in a particular category for each year. Docket numbers may be referred to in different jurisdictions and pleadings. So if it's a civil, it's a civil case, it's going to be filed in a civil court. So, if you had a DWI, it's not going to be held in a family law court. It's going to be held, usually in a county court that deals with DWIs. If it was a DWI and you hit somebody and killed somebody, that's not going to be in a county court anymore. That's going to be in a criminal district court now, because now it's a felony. So, they're filed in different courts with whatever is going to be heard. Officers of the court. The judge is the presiding officer of the court. His or her major duties are to preside over hearings and trials in a case and to rule on issues that arise during the trial. He or she instructs the juries on matters of law in jury trials. The judge may be referred to as the court or the bench. During a trial, counsel may request permission to approach the bench, meaning that they wish to confer privately with the judge out of the hearing of the jury. This may also be referred to as an off-the-record discussion or a sidebar. I mean, you guys have heard that, right? Something happens, it's like, you guys approach. And then the attorneys come up there and they talk to the judge out of the presence of the jury because maybe he or she said something that in a pretrial motion they said, we don't want them to bring this up. We don't want them to bring up that he was convicted of DWI 4 times before this. You know what? That's right, he can't. He needs to be tried for what he was charged with and blah, 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 okay. And then, during testimony, well, isn't it true that you've been arrested 4 times before? Oh, and the judge is like, whoa, approach. So they can, go up there, talk about it, and it's like, you know what? All of that testimony that he talked about, the 4 priors or whatever, is to be stricken from the record. Well, it doesn't really mean that you take it out of the record. It doesn't mean that it just comes out of the record. All it means is if it goes up on appeal, the next, court that's hearing the case or reading the transcript says, you know what, I can't consider that because it was ordered stricken from the record. Okay? Y'all get that?
Should you still be sure, like they have recording things right there next to the judge so you can hear that, right?
Yeah. So, what we have is little amplifiers or whatever, and they're little microphones, and what they do is, we need this bench conference. You know what, I want to stay on the record with this. This is important, but I don't want the jury to hear it. So what you do is you slap on those earphones, and it just amplifies everything, and they're talking up there at the bench, and they're, this far apart. Well, Judge, we had already said in pretrial motions that he wasn't supposed to bring up all that stuff about the DWIs or whatever. You know what, that's correct. I want it stricken from the record, and I'm going to tell the jury that it was stricken from the record. All right, y'all go sit down. Take the headphones off, ready to go. But the jury heard none of this. But it was down on the record because you were asked to stay on the record. Does that make sense to you guys? Okay. The clerk of the court is the administrator of the court and is responsible for the clerical details of the case. The court clerk is the custodian of all public records in most jurisdictions and is the ex officio recorder of the conveyances and mortgages, keeping records of sales and mortgage on property and documents. So what they do is, like, if you want you know, to set a hearing or whatever, you come to the court clerk. You know what, I want to set a hearing before the judge, and this is what it is. Can you give us a day? Yeah, this is it. So they have, you know, they're responsible for a lot of stuff. The clerks are responsible for a lot of stuff, a lot of the dates, some of the judge's personal calendars and stuff like that. So the bailiff is the peace officer of the court and responsible for keeping order. He or she is responsible for the protection of everyone in the courtroom and for maintaining decorum during proceedings. So if anything goes on outside of the ordinary and the judge is like, you know what, get that guy out of here. That's his job. Keeping everybody quiet, keeping peace in the courtroom, that's their job. The jury. The jury is a body of ordinary citizens who are selected to hear a trial by jury. A jury pool may be selected from the tax rolls, voting registration, or motor vehicle registration. In most state courts, a jury is composed of 12 members who are selected after an initial screening process to determine the eligibility to hear the case. So, I mean, you guys know what a jury is. I was just on jury duty last Monday. I got picked. I've been on jury duty 4 times and gotten selected for jury 3. Yeah. And I knew everyone. I knew the judge, everyone, and they're like, yeah, can you be unbiased or, you know, sit here and listen? Yeah, all right. Dave's Roddy, come on up. And, you know, when they start calling, there was 75 of us that went. And it was a criminal case. You know, a guy had possession of drugs. And it was a lot. And it wasn't his first. So, I mean, he was facing 5 to 99 years. So it was a pretty important case. The judgment. When a court issues a decision, it's called a judgment. The court's decision in a non-jury case is also referred to as a finding. Most courts give written reasons for the judgment that set out the legal reasons for the decision. These are generally known as the findings of fact, conclusions of law, and order for judgment. So if you ever hear that, you know, and some attorneys will ask, you know, well, I want the findings of facts and conclusions of law. And the judge will go and, you know, he'll write out why he found what he found. You know, so if it goes up on appeal, then they know exactly why he did what he did. But it's called a judgment. Whenever he renders something, that's what it's called, the judgment. Court chambers and open and closed court. Sometimes the judge may meet with attorneys and parties in his or her office called the chambers, and that's what it's called. So if you ever hear, you know what, we're going to have the attorneys want to speak with the judge in chambers, that's what it means. Now, if you ever hear it, that's what it means. It's just the judge's office. For discussions outside of the hearing of the jury or for decisions of motions, these sessions are also called discussions in camera, which is Latin for in chambers. These sessions are usually more informal than open court hearings. However, the court reporter may bring his or her shorthand machine into the chambers and take down verbatim discussions held in camera. Guys, I've had to do it. You know, when we have a kid that comes in and it's like, you know what? The ad litem says, I don't want that kid in here. I don't want that kid to have to testify in front of his parents, you know, that he or she doesn't want to go home because of what happened to him. So we want to have an in-camera discussion with the kid. Okay, it'll be me, my court reporter, my bailiff. So the judge is usually never alone with the kids, so just in case something happens, there's always somebody there, you know, whatever. But, you know, I've had to go in and take in-camera, you know, things for like an hour. You know, and the judge will sit there and ask that kid, you know, what happened? You know, do you not want to go home, blah, 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 and you know, so, and you're not really allowed to discuss what went on. If the judge goes back and tells the attorneys what he said, then, you know, that's up to the judge. It's not you, hey, what did that kid say afterwards or whatever? Ask for the transcript. You know, ask the judge for the transcript. If he says it's okay, then, you know, you can get a transcript. But if not, then you don't get the transcript. Okay? So be very careful with that, with in-camera hearings and stuff like that. Ex parte hearings in order to show cause. A judge may sometimes sign an order without hearing from both sides of the case when immediate action must be taken to stop something injurious to a person or property, such as issuing a restraining order. Ex parte is Latin for one side or one party. That's what it means. That's all it means, ex parte. And that's what we have. You know, when they come in and somebody calls and says, hey man, this kid's getting beaten bad. You know, and you know, Child Protective Services goes out there and they said, you know what, he is. You know what, call the judge, ask for an ex parte order. You know, and they call the judge, hey judge, we need an ex parte order. This kid is getting beaten bad. I mean, he's, you know, he was in bad shape. The cops are here, and you know, the cops are going to take him to the shelter or whatever. We need an ex parte order to be able to take this kid. The parents aren't wanting us to take him. All right, they'll sign the ex parte orders, and then in 14 days, the state has to come in and prove their case. So they don't just get to take this kid and forever take that kid without a hearing. They have to prove up their case in 14 days. Okay? Make sense?
All these stuff that we're going over,
Yeah.
does that come up on the state test?
Some of it may. Yeah, a lot of it may. Yeah, so I know a lot of this stuff. I mean, we're taking this class for a reason, guys. It's not because maybe I'm going to use it one day. You're going to use it. You are going to use it if and when you ever get out of court-reported school. Okay? So you're going to need it. You're going to need this stuff. So that's the reason for taking this class, okay? So it is important stuff. I mean, and I know that it's a lot of stuff that we have to cover and go over, but I mean, you know, it's stuff that's very important. Okay? Okay, a typical criminal jury trial. Some of the stuff that we're going to go over: define and explain the various steps that are involved in a typical criminal jury trial. Explain the differences between a criminal trial and a civil matter. Explain the differences between a grand jury investigation and a preliminary investigation. Discuss what a coroner's inquest is. Explain how a jury is selected for a jury trial. Explain what the opening statements by counsel are. Explain the differences between direct examination, cross-examination, redirect, and recross. Define voir dire examination. Explain the difference between rebuttal testimony and surrebuttal testimony. Define the testimony by deposition means. Explain a bench conference or sidebar. Describe a jury visit. Explain what the closing arguments by counsel are in trial. Explain what is meant by the court's instruction to the jury. Describe and explain the jury deliberation process and how a verdict is reached. And explain what is meant by directed verdicts and special issues. Okay? NCRA GRMS. When this chapter is understood clearly and discussed appropriately, the following NCRA general requirements and minimum standards may be met. Minimum standard for section 7, judicial reporting institutional standards, subsection E, and what reporting a sidebar discussion is what we're going to talk about. This chapter will take you through a step-by-step overview of the typical criminal jury trial. A criminal matter is one that deals with the person who breaks the law. So that's the difference between a civil and a criminal, okay? You know, a civil is just getting a divorce, contract disputes, slip and falls, whether they're good, you know, child disputes, you know, who's going to get a child, and you know, stuff like that. So, and a criminal is when you break the law, you know. So that's what we're talking about. He or she has committed a transgression against the law of the society and is held accountable. A crime may be classified as either a felony or a misdemeanor. A felony is a crime that is considered more serious than a misdemeanor. A misdemeanor is a crime considered as a lesser offense. The difference between a criminal and civil matter is in terms of the parties to the action and redress sought as a result of the litigation. Generally, in civil matters, one person brings an action against another person for for a wrong. In a criminal matter, a person who represents the people of a community, county, state, or nation brings an action against the person who has been wronged. So usually it's the state of Texas versus so-and-so. And it could be for DWI, possession, murder, homicide, whatever, okay? The Constitution of the United States and the Bill of Rights protects a person's rights regarding criminal investigation and procedure. 1, a person is protected from unreasonable search and seizure. So, I mean, they don't have the right to just come up and just start searching you. They have to have a reason to come up and search you or seize any of your property. They have to have a reason, you know, to pull you over or any of that stuff. And it could be something as simple as a headlight. Maybe you crossed over the line a little bit. He thought, you know, but he has to have a reason to do it. Persons accused of a serious crime must be brought to trial only after an indictment by a grand jury, except in state prosecutions. So, I mean, if the state is gonna, you know, bring it against you, you know, sometimes they don't have to, but, you know, in a murder case, felony cases, stuff like that, a grand jury has to find you, you know, find that there's sufficient cause to bring this action against you or whatever. No person shall be put into jeopardy twice for the same crime. So they can't charge you for something and try you and you were found not guilty and say, oh, you know what? We found some evidence and we're gonna try that guy again. You can't do it again. I mean, there has to be new charges that have to be brought up against you, okay? So you can't be tried twice for the same crime. A defendant is not required to testify against him or herself, absolutely. You don't have to testify against anything. You know, the state has to prove their case. You don't have to prove anything. You can just sit there and they put on their case. Your attorney doesn't have to say a word or do anything. They have to prove their case. No one can be deprived of life, liberty, or property without due process of law. So the law has to prove, you know, you can't be deprived of all of this. So, I mean, they were talking about it the other day. I can't even remember what show I was watching. But you can just be put in jail and they don't even have to give you a reason. They just put you in jail. I can't remember where it was. It was the Soviet Union or something like that. You know, but it was, I mean, in another totally different country. But I mean, they can just put you in jail just because. They don't have to give you a reason, but just put you in jail. You know, in here, they can't just do that. They have to prove their case. Indicted persons are entitled to trial by jury and assistance of counsel and to be confronted by prosecution witnesses and have witnesses in their favor. So you have the right. You have the right to be tried by